him over, so that was nice.
Two of your fellow panelists were open, but Micah,
Yeah.
you should
Yeah, you
all
do.
should speak from the
Oh,
podium
God, no.
for the opening.
Oh,
Is that
really?
okay?
If you want.
What?
Yeah, sure, whatever you,
If
whatever.
you feel strongly, you can. The
No.
rest of you can speak from the.
No, I don't care. Whatever you want.
I don't.
I'm willing to do it.
You have to get more democratic, Todd. You're trying, you know. this
But
is
Mike,
soft
no,
style.
but I see a different. She prefers to. Michael prefers to speak at the podium for opening. You can stay here.
Don't need to.
See, I have no idea. Hold on, give me 1 second. It's these bifocals. These bifocals. My question is, can I actually?
It's a better crowd than I
There's
feared.
a light.
I thought everybody
You're
would bolt,
okay,
I thought everybody
well.
would bolt after lunch.
God only knows.
No, you're a pro. You don't know.
Oh,
the
yeah.
face.
No, because I thought I was
Yeah, I
sitting.
think so. We'll just wait
But in any
another
event.
2 minutes, but I don't.
Hi, guys.
The people can
How are
be
you?
late.
Jonathan, were you next door when they discussed the constitutionality of the Marines Act?
I was there when they discussed the constitutionality of a quasi-weird version of the Reins Act.
Reigns-ish.
Reins-ish Act, but I agree with them on that. I believe that proposal, as I understand it, would be unconstitutional.
Sally, we were on a panel together once before at
Oh,
the
yes.
Urban Institute, I think, at the National
I think
Press
that's
Club.
right.
Yeah.
I think that's right. We were doing,
Executive power. It was Jonathan Turley was there, and this was when he was on his sort of initial.
correct, on his,
Yeah.
on his thing, right.
Well, as always, Boyden sends his greetings. I work for Boyden.
I
Probably
know
okay.
you
Oh,
do.
okay.
I know you
So
do. Are
we'll
we
be
on?
sharp at 3:30.
No, I think we're dead. Are we dead?
I
We
think we're
open?
on, so don't shout any obscenities or anything at me.
Can't take it.
Yeah. I'd cover the microphone for that one.
I made the obligatory
One never knows.
joke about the last panel over there.
In Washington, there's always a microphone on.
But Boyden was on a panel earlier,
That's
wasn't
right. He did the cost-benefit panel.
Well,
With,
then
Were
I
you
think
here
we
for
should
that?
start. Can someone get
I was in
the
the building, but a pal of mine was on the EPA Clean Power Plan panel, and I ducked in for that one too.
So you're talking about oversight?
Yep, talking
Good.
about oversight. Are you talking about oversight?
No.
Okay.
Well, I think oversight's good.
Uh-huh.
So tell me why we have so many hearings on Benghazi.
There's a whole lot of stonewalling. There's a lot of story to be told.
What do you think?
But you need a lot of oversight because so far so much has been overlooked.
Oh, really?
Yeah.
Have they found a shred of anything that implicates anything that Congress should care about? Oh, no, never mind.
I'll let you have the final word.
No, I won't. I won't. In fact, I wasn't going to raise that because it's too partisan.
Well, but if you can't raise partisan things at the Federalist Society, what can you raise them?
I just don't get the sense.
Boy, I stand up here and people get quiet like I'm going to begin. But I will begin. My name is Todd Gaziano. I'm Executive Director of the Pacific Legal Foundation's DC Center and its Senior Fellow in Constitutional Law. And welcome to this discussion of congressional checks on presidential power. So it'll be a little bit broader than just the oversight role that's described in the short version of the agenda. When I heard that this was going to be scheduled the last panel of the day, I knew it was because the Society agreed that these are the most fascinating panelists, the most interesting issues, and the most likely to retain the audience in the post-lunch drop-off. Well, whether you agree or you just need the CLE, you all can participate in our question and answer session at the end. I think it would have helped a little bit if the Society had provided free cocktails for us afterward, but we can buy cocktails for each other. In all events, I do want to thank Karen Lugo of our practice group and Chris Armstrong and Julie Nix from the Society for helping to organize this panel. Sally Katzen also let me know that she may take issue with the premise of the panel that President Obama's exercise of executive power is anything out of the ordinary. But let me suggest at the opening some arguable abuses that this president, and maybe it's just that he's taken the pattern of abuses further, but let me mention a few that the panel might want to consider when it discusses congressional powers. The first is the deadline suspensions, questionable interpretations, and waivers in the Affordable Care Act. And this may be of immediate importance if the Supreme Court rules in favor of the challengers in King v. Burwell in the next couple of weeks. The second are executive actions for deportable aliens, either aliens who were children when they entered the country or their parents and various extensions, their cousins and nephews and pets. Three, we saw the Supreme Court strike down some unconstitutional recess appointments, so we may face that issue again. Four, the administration has issued various regulations of immense breadth, intrusiveness, and questionable legality, and there I would show my bias from the Pacific Legal Foundation, thinking the Waters of the United States rule is both beyond statutory authority and unconstitutional. And of course, we had a panel this morning on the draft Clean Power Rule. We also had discussion in the previous panel of the breadth, I think, an extension of guidance documents from agencies like EEOC that don't even have authority to issue regulations, and these guidance documents have immense influence. And we have some questionable other sidesteps in the administrative process. We have, just to note a few other minor examples perhaps, executive actions cutting the work requirement in the welfare reform law without arguable statutory authority, and questionable No Child Left Behind waivers to coerce the states to adopt Common Core standards. My panelists may have other examples, and Sally might say why this is all wonderful. But anyway, I will now introduce all of them in the order in which they will speak, but to display some of my biases, as they would say in the academy. I was first served as a Justice Department lawyer in the Office of Legal Counsel, defending executive prerogatives in 3 administrations, including 2 years of the Clinton administration. I then had the privilege of serving on the Regulatory Reform Subcommittee, which was a subcommittee of the full committee Jim Bopp served on, that David McIntosh chaired. I helped him co-write part of the Congressional Review Act for the House. Paul Noyes in the back worked for Senator Nichols, and that may be one of the topics that the panel will address, and its next reform agenda. But we worked on other regulatory reform laws and oversight of the executive branch. But I think this is an especially fascinating time with scholarship and public interest in regulatory affairs. So in the order they will speak, Michael Bopp will address Congress's investigatory and oversight powers and perhaps some of their limitations. Mr. Bopp is currently a partner in the DC offices of Gibson, Dunn, and Crutcher. He chairs the firm's public policy practice group and its congressional investigation subgroup. I've got to be very brief in describing his extensive background to allow anyone else time to speak, but of particular relevance, he served in many House and Senate Oversight Committee positions, senior ones at that, and he later then was Associate Director of OMB in the Bush 43 administration. Some of the Congressional Oversight Committees he served on were subject matter specific, 4 were special investigations, and others were almost government-wide in scope. In the late 1990s, he served on these oversight committees primarily in the House. In the early 2000s, he was staff director and chief counsel of the Committee of Homeland Security and Governmental Affairs, which is one of those with the almost government-wide oversight. I think he helped direct over 100 congressional hearings with probably over 1 million pages of documents and thousands of pages of committee reports. Then from 2006-2008, he oversaw large swaths of the executive branch regulatory activity in his position at OMB. In private practice since then, he's represented a number of private individuals before congressional oversight, before congressional investigations. Professor Jonathan Adler will address existing and possible future regulatory reform laws and anything else he likes. Adler is currently the Johann Verhey Memorial Professor of Law and Director of the Center for Business, Law, and Regulation at Case Western University School of Law. Professor Adler teaches courses in environmental, administrative, and constitutional law. He's the author of 5 books, a dozen book chapters and many law review articles. He's often a frequent guest at Congress testifying and commenter in the press, including National Review and the Volokh Conspiracy. Professor Adler is also a senior fellow at the Property and Environmental Research Center, or PERC, and free, well, I'm wearing a free tie, I was testing him, he recognized it. Among other teaching awards, though, I do want to note the Federalist Society awarded him the Paul M. Bator Award for excellence in teaching, scholarship, and commitment to students, and I was a Paul Bator student, so I especially value that award. Next to him on his left, but maybe not philosophically left, is Adam White. Mr. White will address Congress's appropriations and appointment powers, as well as oversight, how oversight and new legislation could influence judicial review of executive actions. Mr. White is counsel with Boyden, Gray, and Associates, and he works on constitutional and regulatory issues. He's also an adjunct fellow with the Manhattan Institute, where he writes on administrative law and legal policy. He co-directs he's involved in two very high-level ABA positions. One is he co-directs their program on Supreme Court litigation, and he is on the ABA Council directing the section on administrative law. Now, he is the third of or one of the three on the panel to have clerked in the D.C. Circuit. The D.C. Circuit, as you know, handles all the most thorny regulatory and administrative law issues. The Supremes just take those easy ones that the courts that the courts of appeals have already resolved. Although Mr. White is not quite as long in the tooth as the rest of us, his legal writings and commentary have appeared in National Affairs, Wall Street Journal, Weekly Standard, and various other law reviews. And last, and certainly not least, is the Honorable Sally Katzen. Part of her role here is to keep the rest of us, to challenge and keep the rest of us honest, and for that we thank her. Professor Katzen is currently a visiting professor at NYU Law School and a senior advisor at the Podesta Group in Washington, D.C. She served almost 8 years in the Clinton administration, first as administrator in the Office of Information and Regulatory Affairs at OMB, then as Deputy Assistant to the President for Economic Policy and Deputy Director of the National Economic Council in the White House, and finally as Deputy Director of Management at OMB. She also served then, more recently, as the head of the agency review group for the Obama-Biden transition, with responsibility over the Executive Office of the President and those agencies with government-wide regulatory authority. Professor Katzen has taught undergraduates at prestigious colleges and many of the leading law schools. She is a member of the National Academy of Public Administration and served on multiple panels of the National Academy of Sciences and is on the board of several nonprofit organizations. Before joining the Clinton administration, she was a lawyer in private practice specializing in regulatory affairs, and she's held many also important positions on the American Bar Association, including chair of the section of administrative law and regulatory practice. And finally, I found it interesting that when she was about 4 years old, she must have been that age, but she served in the Carter administration for 2 years as general counsel on the Council of Wage and Price Stability in the Executive Office of the President. So with that, we'll welcome Michael to the podium first.
Thank you, Todd. Michael Bopp, Jim Bopp, all the same, really, for our purposes here today. You did, that's all right.
Great Americans all.
To the best of our knowledge, we're not related. So I'm going to talk a little bit today about Congressional Oversight Authority and how that authority, we're going to specifically focus on how that authority has been used effectively and not so effectively with this administration. So I want to start, though, with that authority. We need to talk about and understand that authority first, and then let's figure out how it's been applied and why, in certain instances, it has not been applied effectively. So, as folks know, the Congressional Oversight and Investigations Authority is constitutionally based, and it is essentially coextensive with Congress's ability and Congress's authority to legislate. So Congress is entitled and empowered to investigate, to inform its legislative process and inform its legislative authority. Congress is more effective legislating if they understand and if they can dig into the facts and sort of figure out the underpinnings behind legislation before they pass legislation. This general power and this authority of Congress has been to investigate and to issue subpoenas and to enforce its prerogatives has been time and time again underscored and essentially ratified by Supreme Court decisions. Now, you very rarely see congressional investigations and disputes over congressional investigations end up in the courts, and we're going to talk about that in a minute. But the bottom line is that the courts have universally upheld Congress's authority and power to investigate and have been very reluctant to challenge that authority or to limit that authority. Now, congressional committees are where the power lies. An individual member of Congress doesn't have the authority to enforce investigative prerogatives, but committees do. And every standing committee of the Senate and House has the authority to issue subpoenas. Generally, however, subpoenas can only be issued, except with some limited exceptions, with the consent of the ranking minority member or by vote of the committee. There are a few exceptions, as folks know. Over in the House Oversight and Government Reform Committee can issue subpoenas unilaterally, the chairman can, as can, for example, the Permanent Subcommittee on Investigations in the Senate. But generally, the idea is you need either a vote of the committee or the consent of the ranking member. Now, when a subpoena is issued, what does that mean? Does that mean that an entity that receives a subpoena actually has to comply with the subpoena? And if they don't, what are the ramifications? Now, we've seen this play out over the last decade or so, almost exclusively with respect to subpoenas of the government, of the executive branch. You almost never see a subpoena of an individual or a corporation actually ending up in court. That's because Congress has other tools at its disposal to enforce its subpoena, its prerogatives with respect to private parties. Private parties don't want a committee to hold a hearing specifically to hold a private party or a public corporation in contempt. When you even start moving in that direction, or even if a committee starts threatening to move in that direction, that is almost always enough for a private party to come in or a corporation to come in and say, okay, let's sit down and let's talk about this. You don't need to have a vote on whether or not we're in contempt of your subpoena or of your committee. And so really where the enforcement of subpoenas becomes important is with respect to the executive branch. Now, Congress has the ability to enforce subpoenas theoretically in three different ways. There are three different types of contempt. There's inherent contempt, which has not been used since 1935, but it actually is, and there have been some musings sort of among those who follow congressional investigations that inherent contempt may be what we need to resuscitate now in order to effectively be able to conduct oversight over the executive branch. There's also criminal contempt, which both the House and the Senate have. There's civil contempt, which the Senate has, and the House has only if they authorize it on an ad hoc basis by resolution. Criminal contempt is what you see generally with respect to subpoenas issued on the executive branch. And so let's talk about an example. Let's talk about the Fast and Furious investigation. That is the investigation that was conducted still being conducted, by Chuck Grassley in the Senate, jointly with Darrell Issa in the House. And that was an investigation relating to gun running charges that involved the DEA and other government agency or government entities down on the southwest border. And what happened with respect to that investigation was in June of 2012, the House passed a resolution holding Attorney General Eric Holder in contempt for refusal to comply with an Oversight and Government Reform Committee subpoena and to submit documents in accordance with that subpoena. Now, the resolution, and this is how it typically works, authorized the Speaker of the House to certify the Oversight and Government Reform Committee report to the U.S. Attorney and to take all appropriate action to enforce the subpoena. Now, the problem is you now have the power of enforcement, of enforcing that subpoena passed from Congress back to the executive branch to enforce a subpoena against an executive branch official. And so, of course, what happened, the Department of Justice directed the U.S. Attorney not to present the citation to the grand jury. So criminal contempt basically is stalled at that point. So what happened is, in August of 2012, the Oversight and Government Reform Committee, through the House Office of General Counsel, I see Mike Stern here, he used to do this, filed a civil action against Holder, requesting that the district court enforce the subpoena. Now, the Department of Justice's motion to dismiss was denied. Settlement negotiations stalled. The Department of Justice eventually was compelled to produce over 60,000 documents over which privilege had been probably improperly claimed. The problem, however, is that this litigation has been pending since August of 2012. And so here we are. Darrell Issa is no longer chair of the committee. It's changed hands. Now it's Jason Chaffetz. Chuck Grassley, while still interested in this issue, has moved on to other issues as well. And so essentially, the waiting game works. And again, Congress does not have an effective way of enforcing its prerogatives against the executive branch. So what can be done? So let's talk for a moment about the Benghazi investigation. Now, here's a special investigation. Trey Gowdy, former prosecutor, is leading that investigation. I think he's doing an excellent job. I mean, most of what is going on, and it's been going on for well over a year now, has been going on behind the scenes. What you don't see is a lot of press over the investigative methods and the actual investigating that is going on. You do see a lot of press over Hillary Clinton having to come in and testify before the committee at some point. But what that committee faces is essentially the same problem, and that is a problem of how to enforce its prerogative. And where almost in all cases where Congress is going to be interested in investigating the executive branch, you're going to have a Congress of one party, so chairs of congressional committees, investigating an administration of another party. And so you get to the point very quickly where contempt doesn't work. So what can work? Where can we go within the bounds of the constitutional authority of Congress in order to hold administrations accountable whenever Congress or when Congress wants to exercise legitimately its investigative authority? So there are a couple of ways that Congress, or a couple of things that Congress can do, and sometimes they do to good effect. So one thing that Congress can do is, if the government is not providing or producing information, oftentimes there are non-government agencies with whom the government is communicating. And so Congress can go to those non-government entities that are communicating with the government and asking for, the email traffic, the communications with the government. That has been effective both in the Fast and Furious investigation and in other investigations of the executive branch. I'm running out of time, but let me just note one other idea, which is not my idea, but which is a very good one. If Congress had, let's say, the will and the discipline to do this, Congress could use its appropriations authority, which is going to be discussed later, to enforce its subpoenas. So if the executive branch refuses to comply, theoretically, Congress could say, fine, we're going to use our power of the purse, we're going to dock you in certain areas, and we're not going to, you're going to pay for noncompliance through appropriations. The problem is passing a bill. Passing a bill whenever an enforcement action has to, or enforcement has to occur. So what would really have to occur is Congress would have to create rules under which consequences under the appropriations process would be automatic. Difficult to do, but conceptually possible. I know I'm out of time here, so I'm going to stop, and we will continue the discussion during the Q&A phase. Thank you.
It's a pleasure to be back here and to once again be at this conference and to talk about an issue that's near and dear to my heart, which is what to do about executive branch regulation and concerns about the scope, scale, and substance of executive branch action to enact rules and adopt rules that tell us what we are or are not allowed to do, tell businesses how to operate their businesses, perhaps tell others everything from whether they can come into the country, whether or not they have to buy health care, or what have you. Now, I think generally, as an opening point, I think Congress should be concerned about the rate at which the executive branch adopts new regulatory initiatives, adopts policy measures which look a lot like the enactment of legislation in terms of their scope and in terms of the policy decisions that are involved. I don't think this is unique to this administration, although I think it is fair to say that there has been more of that under this administration than their predecessors. In 2014, federal agencies issued over 3,500 new regulations. The current administration is averaging 81 major rules per year, major rule defined as generally as a rule that is anticipated to impose over $100 million of annual costs. By comparison, the number of major rules per year in the Bush administration was in the 60s. Many of us may think that's too many as well, but the trend is certainly upward. Now, a lot of the complaints about various regulatory initiatives are that they are ultra-vires actions, that agencies are exceeding the scope of their legislative authority, and that leads to rhetoric about an administration behaving in a lawless or unlawful or perhaps even unconstitutional fashion. And I think it's certainly concerning when an agency does act in excess of its lawful authority. But I think what we tend to overlook, and I think what Congress too often tends to overlook, is that the scandal is not only what agencies do that's lawful, but much of what agencies do that is perfectly legal. Most of the regulations that federal agencies issue every year, most of the major rules they issue every year, are regulations and rules that are authorized and indeed in some cases required by the legislation that Congress has enacted. Agencies have no inherent authority. Certainly not in the domestic arena. We may debate about whether the executive branch has some degree of inherent authority when it comes to foreign affairs or national security, but domestically, agencies only have that authority that Congress has given them. And if they have too much authority, or if the boundaries of that authority is insufficiently clear, ultimately the responsibility for that is not in the White House. It is in Congress. And if Congress is concerned about executive overreach, concerned about the extent to which policymaking initiative is occurring at 1600 Pennsylvania Avenue rather than on Capitol Hill, Congress is ultimately the entity that has to take responsibility. In some respects, it's like having a teenage child, and I have a teenage child, so I can speak with some experience here, and when the teenage child wants to go out one evening, you just say, oh, go out and do what you want. Do whatever feels good in the moment. See you tomorrow. If your child makes choices that you might not approve of, perhaps, yes, your child should be more responsible, but perhaps you should have given better instructions, more limitations. Perhaps you should have said something about what their curfew is, about what sorts of things they should or should not do, perhaps whether they should comply with the law, respect a curfew, not go to certain types of parties, and what have you. Yet Congress routinely passes legislation that are no more prescriptive than that, telling agencies to do what's in the public interest, to do something that safeguards public health with an adequate margin of safety. Well, what's adequate? I don't know. Well, the agency will figure that out. And on top of that, the Supreme Court, in a decision from a few years ago, Arlington versus FCC, said that if there's any lack of clarity about the scope of the agency's authority and what's delegated, we'll just defer to the agency. They tell us what the scope of their own authority is. Thank you, Justice Scalia. So what do we do? I mean, ultimately, Congress has to step up. It requires more than things like oversight investigations, although those are certainly very important, particularly if we want to know if agencies are acting within the scope of their authority. But Congress does have to do something to address delegation. I share some of the skepticism that was expressed on the last panel about relying upon the judiciary to police delegations and to place any outer bounds on what sorts of delegations are permissible. I should say I am also skeptical with a lot of the conventional regulatory reform proposals that get put forward, proposals to add additional analytical requirements, to add additional procedural hoops, perhaps require more agencies to go through formal as opposed to informal rulemakings. Making agencies spend more time and money to enact new regulations will slow them down, but it does not address the underlying problem. The underlying problem is that agencies are essentially acting without much accountability and responsibility. They are exercising authority that was perhaps granted to them 10, 20, 30, 40 years ago, and in no way are reflecting the priorities of those who are currently elected to represent the American people. So those sorts of proposals, whatever their merits on other grounds, I don't think solve the underlying problem of agencies acting without sufficient accountability. So what else might we do? Well, we could certainly amend all the individual statutes one by one. We know that's not likely to happen. Our system is hardwired to have substantial inertia. It is difficult to pass legislation that is by constitutional design, and those obstacles are increased by internal congressional procedures which have, I think, many good reasons, and amending organic statutes one at a time is not likely to address the broader systemic problem. As was mentioned on the last panel, agencies often decide to take a course of action feeling that somewhere within the US code there is probably something that they will be able to fall back on to justify what they've decided to do. You don't address that problem by trying to amend each statute one at a time. We could sunset regulatory authority. We could say that if a statute has a time-set authorization, as some statutes do, when that authorization expires, any rulemaking authority that an agency has expires with it. Congress could certainly make that explicit, but of course that would only affect new legislation. But I think it certainly would be responsible and something that Congress should do. The 1990 Clean Air Act hasn't been meaningfully modified in 25 years, and yet is the source of some of the most far-reaching, costly, and controversial rulemaking initiatives currently underway in this town. I think it's fair to wonder why it is that policy decisions of this magnitude, of this importance, are being based on something that Congress last gave its okay to over 2 decades ago. The Congressional Review Act was one idea that people had to deal with part of this problem, the idea being we'll create an accelerated process through which Congress can review and reject a regulation that it doesn't like, and certainly that reduces the transaction costs that Congress must go through to overturn a regulation. But as a practical matter, we know the Congressional Review Act is only effective at repealing or overturning those regulations adopted at the very end of a presidential term, because these resolutions, like all congressional resolutions, must go through bicameralism and presentment, so they are subject to presidential veto, and it's very rare that a president is going to sign a law repealing a regulation that one of the president's own agencies has promulgated. So the Congressional Review Act really doesn't do much, again, other than making it more difficult for one administration to adopt last-minute rules to bind its successor. One possibility that I am more bullish about, and I'm going to spend the balance of my time talking about, is something that's been referred to as the REINS Act. But the basic idea is this, is if the problem is excessive delegation, the problem is that Congress hands the keys to the regulatory car to agencies and doesn't look back, well, then the answer is to take back the keys. The answer is to impose more restrictions on agencies. The idea of the REINS Act is really rather simple. It's to require legislative approval to major rules before they become effective. Essentially what it says is, agencies, you have authority to issue minor rules and to promulgate those and to have those take legal effect on your own. But major rules, those that are of sufficient magnitude that we might think our legislators might want to have something to say about it, or they may not want to have something to say about it, but perhaps they should have something to say about it, those are merely advisory. Those are recommendations. They're like the other sorts of recommendations that federal entities sometimes provide to Congress, that Congress can then decide to adopt or reject. It is a constitutionally permissible alternative to the unicameral veto that was struck down in Chadha, and a constitutional alternative that, interestingly enough, was perhaps first suggested by a guy named Steve Breyer, writing a few decades ago. Generally, and I see that I'm out of time, so let me just say the idea is you would create an expedited legislative consideration of these major rules, much like is authorized under trade promotion authority. Congress gets the option to vote up or down. Congress doesn't amend. Congress can't filibuster. We get to know whether or not our members of Congress support or oppose these major rules. We get to hold them accountable for it. They can no longer say, oh, I didn't vote for that. I wasn't even in Congress when the 1990 Clean Air Act was adopted. I'm not responsible for what the EPA does now. Or I voted for a bill that said protect the environment and care about costs. I just didn't say anything about how to make that trade-off. And so we'd be able to hold members of Congress accountable. I know that Sally will explain why this is a bad idea, and we'll probably get to have some back and forth on this in the Q&A. But the bottom line is, if we care about executive overreach, we need to do more than point the finger at the executive. We need to point the finger at those that are the source of much of the executive's authority, that is Congress, and ask Congress to do more to restrain the authority that Congress delegated in the first place. Thank you.
Now, when Todd introduced me, he very gently pointed out that I have far and away the shortest CV of anybody on the panel. So, well, the implicit warning for the next 10 minutes is caveat emptor. Now, that said, I'm learning, and I feel like a lot of us have learned in the last 6 years some new things about executive power, administrative power, and how it fits in our system of government. And so I have just a couple of quick reflections on that. One lesson that we've learned that doesn't get as much attention as the rest, but I hope it gets more than it has so far, is the power of the purse. Being a Federalist Society event, I'll begin with the text, with Federalist 58 and James Madison's recognition that, quote, the power over the purse, Congress's power over the purse, may in fact be regarded as the most complete and effectual weapon with which any constitution can arm the immediate representatives of the people for obtaining a redress of every grievance and for carrying into effect every just and salutary measure. More recently, the Senate, in a 1977 report on the administrative state, pointed out that the appropriations process is the most potent form of congressional oversight, particularly with regard to federal regulatory agencies. Now, in the previous panel, Professor Metzger pointed out that, by and large, Congress still has its power over the purse and it wields it, but not in every case. And I think there's an important example that I'd hold up, and it's the new Consumer Financial Protection Bureau. The CFPB was created not just to be independent of the president, but also independent of Congress, specifically by taking away Congress's power of the purse. Congress doesn't fund the CFPB. The CFPB draws about a $600 million check every year from the Federal Reserve. This isn't an accident. When the executive branch originally proposed the CFPB, they called on the agency to have, quote, a stable and robust funding stream outside of congressional appropriations. Why? Well, as the Senate Banking Committee pointed out, making the CFPB independent of the congressional appropriations process was absolutely essential to prevent future Congresses from influencing the CFPB. The last four words of that are mine and not from the quote, but that's what they were getting at. And in fact, the CFPB has made good on that promise. More than maybe any other agency, the CFPB ordinarily and aggressively resists any sort of meaningful oversight over what it's doing and why. The CFPB has repeatedly thumbed its nose at Congress. Anytime Congress tries to ask, why are you spending so many millions on a lavish new building? Why are you stretching your regulatory authority way beyond what we originally provided? At each and every turn, the CFPB just flips, thumbs its nose, we'll say, at Congress. It would be one thing if this were just one agency, and so far, I guess it is, but the thing is, the CFPB, if left alone, will probably serve as the model for future independent agencies. The next time a crisis calls for a new regulatory reorganization, no one's gonna say, let's create another FTC. People are gonna say, let's create another CFPB. And so I think, in fact, the SEC, a couple of years ago, under Chairwoman Shapiro, said we need our own independent funding. The CFTC's Commissioner Chilton said we should have our own independent funding. This is not an accident. They see what the CFPB can do, and they want some of this themselves. And so my first advice in terms of congressional oversight is at every turn, resist the request for an independent funding stream for agencies outside of the appropriations process, or else the congressional oversight process will lose any real potency. My second point, in the short run, what can you do with congressional oversight? Well, I would recommend you should not consider oversight in a vacuum. You should think of it, you must think of it in the context of the rest of government, including judicial review, the relationship between oversight and judicial review. Ordinary judicial review of agency actions, as deferential as it is, basically rests upon at least two basic theories of administration. One is that agencies, not courts, are politically accountable. And two is that agencies, not courts, have technical expertise. And so for both of those reasons, courts should either formally or informally afford a measure of deference to what the agencies are doing. Now, I think the oversight process can help cast a more realistic light on exactly what the agency is doing, whether through agency hearings and reports or through the inspectors general. I think there are plenty of opportunities for Congress to show to what extent the agencies really are guided by political accountability, the extent to which they are guided by actual expertise. I remember back in 2011, the CFTC's Inspector General issued a report revealing how warped the CFTC's cost-benefit analysis was. They said the cost-benefit analysis was, in effect, the caboose at the end of the regulatory process that was driven almost exclusively by lawyers, rather than through sound cost-benefit analysis at the front end of the process. That report came out just a couple months before the famous Business Roundtable versus SEC case out of the DC Circuit. I'm not saying that the report influenced the case. It surely didn't. But I think these sorts of reports can help foster a more realistic atmosphere around agency litigation in the long term, and I don't think you should undervalue that. Similarly, the House Oversight Committee issued a report a couple years ago showing what really did happen behind the scenes in the executive branch in trying to force the auto companies to come to the table on greenhouse gas regulations. I think more reports like that would give the courts a much more realistic view of exactly what is happening in the agency process. Third, I would note in terms of cost-benefit analysis, and I know there was a panel on this already, just a very brief note that we tend to think of cost-benefit analysis as something that happens in the agencies and in OIRA. I think it would be good for more of that to be undertaken in Congress. I'm not saying that Congress should replace OIRA and the agency's own cost-benefit analysis, but I think it's good to get a multitude of voices on these issues, a second set of opinions from Congress, the CBO, at least in selected rulemakings, whether it is forward-looking cost-benefit analysis, challenging the analysis of the agency in, say, a new Clean Air Act rule, or if it is a backwards-looking review, a look back to see exactly how well did the agency's analysis hold up in the aftermath of maybe 10 years of hindsight, to show what the agencies are doing right, what they're doing wrong, to the extent to which, to borrow former OIRA Administrator Dudley's line, to the extent to which they're promoting puffery, I think is your phrase. If nothing else, maybe backward-looking review would foster a bit more, as some say, epistemological modesty among the regulators. My final point, and I know I'm running short, so I'll be quick. Sally can have my extra minutes if there's any left. As we think about reform, substantive reforms of the underlying statutes are important, obviously. Overarching substantive reforms like the REINS Act are very important. But I also am a big fan of procedural reforms within the agencies. Administrative Procedure Act reform, and specifically things like the Regulatory Accountability Act and other measures that would reform, supplement, or change the procedures through which the agencies must go and the extent to which the agency's work is subjected to judicial review. I think it's very important. Right now, the Administrative Procedure Act just doesn't really reflect administrative reality. Anyone who's practiced in this town knows that. There's a good article that came out recently by Michael Grieva and Ashley Parrish that documented this, but whether it's waivers, whether it's regulating through so-called guidance documents, regulating through so-called frequently asked questions web pages that are increasingly forming the basis of what actually governs people and companies in the real world, none of this is really within the framework of the Administrative Procedure Act. I think of it, I like to call it passive-aggressive regulation, the way that which the regulators are saying, oh, we're not actually doing anything, but we all know exactly what they're doing, and we know that it has a very real impact. Now, I spent some time looking back through the Administrative Procedure Act's legislative history. I wouldn't recommend it, but in fairness, I was paid to do it for a brief. If you look back at the debate from the 1920s through 1945 and 46, what Congress and the executive branch really did was try to grapple with the administrative state as it existed and how it actually operated in the real world, and to try to construct a framework that spoke to the real world at the time. And so I don't think there's any harm in Congress and in others attempting reforms in the same spirit, reconstructing or amending an Administrative Procedure Act to really grapple with what's actually happening, not just for the sake of punishing regulators, although a little bit of that's okay, but in an honest and genuine spirit of good government, and the notion that the laws we're operating with ought to actually speak to the reality of governance and not just be sort of a relic from the past that we pretend really applies while we do something different. And to the extent, my last point is, to the extent we are going to amend the APA through the Regulatory Accountability Act and other measures, it's very important to make sure that these procedures are subjected to judicial review. Otherwise, it's going to be an empty threat, a dead letter, whatever you want to say, without the teeth of judicial review, not judicial micromanagement, but firm, real judicial review to make sure the agencies actually went through their paces. That's all I'm asking for. But just adding that much and making sure that judicial review reform is part of APA reform, I think would be a good start. Thank you.
He left you 3 extra seconds, but we can yield you maybe an extra minute.
I appreciate that, Todd, very much. I have to start by saying I am delighted to be here. This is not the first time I have entered a session of the Federalist Society. I've been invited before, and I hope after today I'll be invited again. I truly believe that almost all the discussions I've heard at Federalist Society meetings are engaged with very smart people, with very civil discussions and disagreements that are inspiring, imaginative, and sometimes provocative. And I appreciate the inclusiveness of inviting someone like me to talk to someone like you. I think it's great. No, it really is. Todd said I was going to spend an itty bit of time just raising questions about the premise of the panel discussion today, now, and what you have been talking about all day, and that is that the executive branch currently is overreaching, and Todd gave 5 or 6 different examples. And I'm sitting there thinking, plus ça change, plus c'est la même chose. I did that during the Bush administration. I could list all sorts of things that I thought was aggressive behavior. And you know what? When I was in the Clinton administration, I was constantly told that we were pushing the envelope. We were doing more than had ever been done before. And then I remembered being an observer of the Reagan administration, thinking, good God, what are they doing? Kind of thing. So I think that this is simply, or not simply, but I think there is an element of this that comes from divided government, which the American public has given us, I think, in all but 7 of the last 25 or 30 elections, where you have one party that has control of 1 or more of the houses of Congress, and the other party has control of the White House. So one of the thoughts I had for today was, do we have any data on what's happening? As an OIRanian, along with Susan Dudley, I actually believe in numbers sometimes. So I looked at executive orders. And from Washington through the beginning of the 20th century, somewhere between 1 and 200 executive orders per president. Teddy Roosevelt, 1,081. Not to be outdone by Woodrow Wilson, 1,803. And Coolidge, 1,203, all of them outdone by FDR. this won't surprise anybody here, 3,721 executive orders. He did have a few more terms than some of the others. Now, following that, many, many fewer, more than double digits, but rarely coming anywhere close to 1,000. And then I thought that what was interesting is that Obama has 206 executive orders. George W. Bush, 291. Clinton, 364. Reagan, 381. So not exactly shockingly different. And I sort of thought that maybe numbers don't tell the whole story, and that it could be that the measure of aggressivity lies in the eyes of the beholder. And in that sense, I was intrigued last week when I saw a little squib that Senators Murkowski and Cornyn, who have been trying desperately to get rid of a decades-long ban on U.S. crude oil exports, were so frustrated that they, quote, went so far as to call for President Obama to use unilateral executive action. Ironically, a favorite point of attack for Republicans. But it can help you sometimes get where you want to be. Regulations, is that the problem? And Jonathan gave you some figures about the average during the George W. Bush years, the average during the Obama years of major rules. There are lots of metrics, lots of measures. Some use pages of the Federal Register, pages of the Code of Federal Regulations, code of all sorts of things. And I have to say with all of those that while there are some upticks, they're not shockingly out of line, which is not necessarily a measure of the cost or the burden or the intrusiveness. And I take it that many people believe that we just keep going and going and going, like the ever-ready bunny. But I think it's important to note that this keeps building on itself because Bush had more than Clinton had more than Reagan, et cetera, et cetera. So I think what the issue is for my fellow panelists and for many of you in the audience is the concern that the current Congress, and Jonathan sort of mentioned this, the current Congress may not approve of what the current administration and the agencies, how they're using their discretion. There's just a disagreement on some of these policy issues. That the result of that is to impair Congress or to diminish Congress or to weaken Congress, and that Congress should do something to right the balance. Now that, I think, is a fair question and a serious one to discuss. But to do that, I think we have to ask a question which was asked during the luncheon. What's Congress? Who's Congress? Is it a very vocal minority in one house that is nonetheless part of the leadership or nonetheless has access to the power of the purse? Is it a majority of each of the houses, but shy of 60 in the Senate? Is it the majority of one house and a filibuster-proof in the Senate, but not the president? And that becomes relevant when you start thinking about what they can or cannot do, because I think it matters who this Congress is that doesn't like what the agencies are doing. If a single member or a committee of either chamber wants to write an agency for an explanation or urge an outcome, CEG Dinglegrams, named after John Dingell, that I think is wholly appropriate. If they want to have an oversight hearing, which Michael was talking about, I think that's wholly appropriate. That's a committee. And if the Senate wants to hold up a nominee to an agency, I use the singular out of spite, an agency, because of a point of substance from that agency, that may well be legitimate, although I suspect that the substantive point will get lost in the fact that the confirmation process is now totally broken. These are actions that are reserved to the members, to the committees, to the chambers. But I think there is a line drawn in the Constitution, that when Congress wants to make law, which is its constitutional function, to make the laws, then it must act, as the Constitution says, with the bicameral and the presentment. And it can't skirt those when it's doing its law making. That's why we can use the appropriations riders, because they're passed by both houses and presented to the president. One suggestion which has not been heard today is use more precise delegations. Yes, that's true. Or another, decide that they want to change the law because they don't like what an agency is doing. Yes, that's within their prerogative, so long as they meet the bicameral and presentment. Now, Jonathan says that there's an inertia. They don't want to do this. Well, then how, under the REINS Act, are they going to affirmatively vote on 100, 85, 50, 20 major rules? Because there is the inertia, and there's just an unfathomable workload that would come about this. I would say that Jonathan and I agree on these other bills, which Adam seems to like, that would add process and procedure. He called it the Regulatory Accountability Act. I think that is the name of the current version. With respect, I don't think it deals with the regulatory state as it is now. I think it engrafts onto the procedures, more procedures, more procedures, and more procedures. Is that to produce a better, more thoughtful outcome, or to grind sand in the spokes of the wheels and slow the administrative state to a halt? Whatever it takes. I have a half a minute. Whatever it takes. All right. That leads to the second question. Once you figure out who is the Congress, tell me what the objective is. If the objective is to roll back some of the regulations that have been issued, to go back in time, pre-FDR, when we could all enjoy liberty, when we could do everything that we wanted to do, let's be clear and state what our objective is. And if there is consensus in this country, we can get there. But if the objective is to actually have better, more thoughtful government, there are other paths we should follow, and I'll leave those for questions and answers.
Okay. Thank you all. We're going to engage in a little bit of crosstalk first. And what I do is I have a question for each of you, I've decided, but you can also respond to others. You can respond to others first or after my question. So we'll go in the same order. Michael, Adam talked about other purposes besides just getting the information that you would get in a subpoena of oversight hearings, and I know you are aware of those, but when I was on the Hill, the sense was, when I was in OLC, we were very afraid of the effectiveness of the Dingles and others, and the sense was that the GOP just didn't have their heart in it, members didn't show up. Now the staff, of course, like you, were excellent, but and it wasn't just a function of the press being cheerleader to one side or the other. Are conservatives genetically less capable of a sustained oversight, or do I have it all wrong?
You know, it's so personality driven. I mean, you asked the right question, because most members of Congress, most chairs of committees don't have it's just the way Congress is created and the incentives that are there for, you know, a constant stream of publicity and, you know, quick gratification. Most members do not have the Constitution and the willingness to do a sustained, lengthy investigation. I mean, you look at Carl Levin. Before he left, he spent 2 years investigating the causes of the financial crisis before he held his first hearing.
Weren't there 300 hearings on Katrina? No, just seemed that way. You were involved in some of them.
I was, but it's personality driven. So I believe there are members on the Republican side that are willing to take a longer view on investigations. I think, for example, Rob Portman taking over the Permanent Subcommittee on Investigations, they're embarking on long-term investigations along the lines of a Levin or, to some extent, a Dingell or a Waxman. It's got to be done, and I think you have to have members who understand or who defer the gratification for something important, more important down the road, because you just cannot do an investigation where you break a lot of ground if you don't take the time to enforce, to gather the documents and to enforce subpoenas. If you issue subpoenas, you do the investigation, you do the interviews, the depositions. It's like civil litigation. It takes time.
Okay. Any other comments on the other panelists, Michael? And Michael is your first.
It is.
You yield the floor?
I do.
Okay. Jonathan, I understand that you have testified recently on the House's lawsuit against the executive branch, and the provision that I think we both agree is the most substantial is the one that I think this audience may know the least about. But would you comment on both merits and likelihood of success?
Yeah, I mean, the hearing was on ultra-virus actions in implementing the ACA that the Ways and Means Oversight Committee held about 2 weeks ago. But several of the issues are those that are subject to the lawsuit. What's interesting is that one of the claims in the congressional lawsuit is that the administration acted illegally in waiving the employer mandate and then delaying it a second time selectively for different groups, even though the law is written in a way that the mandate operates as a tax. Certainly according to the administration, it's a tax that takes effect on a date certain. That is, the tax liability accrues as of a date. So to waive that is not an exercise of enforcement discretion. It's waiving a self-executing legal obligation. The other aspect of the congressional suit that hasn't gotten as much attention, but that appeared to be of particular interest to the judge that heard some argument in the case also about 2 weeks ago, is that one of the provisions of the Affordable Care Act authorizes cost-sharing subsidies that are paid directly to insurance companies to help defray the costs of providing insurance to a subset of low-income individuals. The administration initially maintained, as I think most people expected, that these subsidies, as opposed to the tax credits at issue in King versus Burwell, require congressional appropriation. And so they were part of the administration's appropriations request. Congress did not appropriate the money. The next time the administration made an appropriations request, they no longer included this as an item, and they wrote the checks. This is particularly significant, what everyone thinks about the standing issues in the congressional lawsuit, and I think those issues are quite serious. It is a remarkable thing, because here is, as Adam talked about, one of the most fundamental checks that the legislature has on the executive branch, controlling money, deciding whether or not to appropriate money to a particular program, and the administration, in the face of Congress failing to appropriate that money, simply spend it anyway, even though the administration had previously acknowledged that it required an appropriation for this money.
It made an appropriation request even.
And yeah, it had made a request. And actually the judge in this case has actually asked for additional information about precisely how the administration suddenly changed its mind. Both that and the employer mandate delay, I think, are examples of things that should concern us, because they do, just as a complete executive branch unwillingness to respond to a subpoena from an investigating committee would be a fundamental challenge to Congress's ability to engage in oversight. The administration's asserted authority to waive a provision of law that is self-executing, that takes effect on its own, which did with the employer mandate, an administration's claim to be able to spend money that is not an entitlement, that requires an appropriation, but for which there has been no appropriation. Those strike at the heart of the checks that Congress has on the executive branch short of impeachment, and there's sorts of things that should be very concerned. And I should just, last thing about this hearing, I've been going on, but it was really interesting at this hearing, at the beginning, most of the folks in the minority, yet another Obamacare hearing, Obamacare works. So at the end of the hearing, Charles Rangel, unfortunately after most of the press had left, gave an extended statement saying, apart from our differences on the Affordable Care Act, there are some really fundamental issues here about the legislature's ability to maintain its authority vis-a-vis the executive branch, and that insofar as the legislative branch is concerned about making sure the executive branch is complying with legislation, that's something that members of both parties should be able to agree on is important. I hope that's a sign of things to come, and I hope it's something that would continue without regard for who the next occupant of the White House is, because there are institutional prerogatives that need to be maintained.
Any other comments on other panel?
We'll leave them if those specifics come up. So.
Adam, I think I told you the question I was going to ask, which is that, sure, there's a lot of interesting things, and I think Professor Hamburger, for example, has made some good points about APA reform on, let's say, fact-finding in the agencies and other determinations. But on Chevron, let me offer my legislative proposal. Congress passes a law saying when we give a huge range of discretion to the agency, or if we have in the past given a huge range of discretion, the agency can't pick any point in between. They must choose the way of satisfying the statutory purpose that is the least burdensome. And the courts are then instructed to provide de novo review without deference to the agency. What would be some of the implications? Not that Congress would necessarily pass that right away. I'm sure the courts would partially evade, as we've heard from a lot of other scholars, but wouldn't that kind of reform change the deference that Clark Neely was complaining about?
Yeah. And just to clarify, so I was jotting down a note, are we talking about deference on factual issues or legal issues?
Legal issues.
Okay, on legal issues. Well,
legal authority of the agent and the scope of the type of regulation to implement the statutory objective.
Right. I mean, I am sympathetic to some of Professor Hamburger's, many of the basic thrust of his argument. I do think there are significant problems that we've seen with Chevron deference, both as it's conceived and as it's been carried out. That said, even if Chevron has real problems, sometimes I wonder if maybe we ought to stick with the devil we know versus the devil we don't, because I don't know exactly what we would replace Chevron with. If we had full de novo review, I don't know. There's some definite virtue to that. On the other hand, when statutes that you're interpreting are written in such vague terms, broad terms, I'm not always sure that we shouldn't at least begin with a presumption in favor of deference to the agency's interpretation of the statute committed to it. I'm not saying I'm completely...
Well, what about the first part then of my imaginary reform,
Yeah.
which says that what is being reviewed is whether the agency has chosen the least burdensome alternative?
Oh, sure. I mean, I think there's something to be said for that. Putting the agency through the process of analyzing the alternatives, comparing the competing benefits and drawbacks to both is good. I think the way I'd see it playing out is if we created that framework, you'd suddenly have the agencies getting much more clever in how they're defining their mission of what they're trying to undertake, defining their interpretation of the purpose of the statute, and voila, the policy they want to pursue will just happen to be the least burdensome one that still checks all the boxes of the policy preferences that they think they need to pursue under the statute. If that's satisfactory. And I'll just say about Chevron, to some extent, I think legislating reform of Chevron, if you don't change the culture of what the judges are trying to do, if you don't change the underlying statutes, you may end up just pushing on a string where courts will defer without saying they're deferring. Can I pop just a couple of comments in about That's Sally's comments, actually. You had a variety of very challenging points in there. 3 jumped out at me that I wanted to respond to very quickly. And I will say, as my wife and friends will vouch, I'm the least literary person in the world, but your comments inspired me to recall a couple of lines I like to keep in mind. First, when you talked about having been on both sides of these debates, and we've all been on both sides of these debates from administration to administration, and I don't mean to speak for everybody, I just mean in general. If your implication was we maybe should regret that we're changing, our instincts from administration to administration, I don't think that's a bad thing. The line that came to mind was hypocrisy is the homage that vice pays to virtue. I think it's good that our instincts, our policy instincts and political instincts, often from administration to administration, leave us on opposite sides of this debate. I think in the long run, it encourages all of us to think about it from both sides of the table, and then in the long run to think a little bit more nuanced about these issues. And so I would not, I guess what I'm saying is, don't beat yourself up over having been on both sides of these issues. It's okay.
I stopped beating myself a while ago.
Oh. The second, on your question, what's the Congress? As Walt Whitman would answer, I contain multitudes. I think it's hopeless to try to come up with a unified theory of Congress. I think Congress is a single body. I think it's an organization of committees. I think it's an organization of individual officers, each elected on their own and with the help of parties. And so if our task is to come up with a unified theory of Congress, it's going to be hopeless, and I don't think it'll resemble reality. I think we should just grasp the reality of Congress at each level and try to do our best we can with each. And I'll leave it at that, actually.
Okay. Sally, I think I have 2 questions for you. The first is, just because it seems like every administration is more abusive than the rest doesn't mean it's not so. But that's my statement. That's not my question. My question is, in evaluating executive actions and regulations, I've always been frustrated by the number game. No matter how many wonderful executive orders, to take that example, Franklin Roosevelt issued, he authorized the internment of the Japanese, which seems to me so horrendously wrong and unconstitutional to have, wiped out any, Groundhog Days, he declared. And Truman, by contrast, one of my heroes, desegregated the armed forces with an executive action that I think was within his commander-in-chief authority. Wonderful use of executive. So shouldn't we look at whether there are executive actions, whatever we call them, and by the way, I think part of the criticism is we now call them all sorts of different names, FAQs, we can call them Sally for all we want. No, not Sally, okay.
If Sally is going forth.
Okay. Isn't that a better measure of the angst? And my other question that I warned you in email I would ask is, I did read your law review exchange with Professor Adler on the constitutionality of the proposed REINS Act, and as I understand it, to oversimplify, you were saying that it didn't expressly overrule all the other organic statutes that require rules to be issued by a certain date or time, and it left the president in this quandary, and that repeals of legislation were disfavored by the Supreme Court, so the Supreme Court would. What if the REINS Act, since it hasn't been enacted, were just expressly stated, yes, we hereby are amending every single organic act to the contrary, and requiring that no major rules as we define them can ever go final until Congress enacts them under would you have a constitutional, you would have a policy question which you can describe, but would you have a constitutional question?
Yes.
Do you want to explain?
Yes. First of all, the concern with not explicitly stating we are hereby overruling all laws, we don't know how many, we don't know what the effect will be, and we don't know where the consequences will flow, was a suggestion for truth in legislating, not a constitutional question. The constitutional question comes down to whether it is a violation of separation of powers under the old Morrison versus Olson type analysis, where Congress is not only aggrandizing itself, but is also impairing the ability of the executive to execute the law because interpretation is part of execution, is one argument. The second argument is that a law would, a regulation would not become effective unless if one house declined to approve it. That's chata inside out. And I don't think people would be much disturbed. Jonathan's going to want to respond to that, and that line is getting longer down there. But let me just say two quick things. I'm not beating myself up. The fact that you look at another administration and say, ooh, is a consequence that elections have consequences. And the American people have selected someone whose views I may not agree with, who is now aggressively doing what he said he would do. And then we have another election where someone I may agree with is elected, and that has consequences too. I'm simply observing that in a divided country, and we are deeply divided on some issues, we're going to have two sides. And depending on who is in the White House, you will have two reactions. It doesn't mean, and I would agree with you, if each one is getting more aggressive, that doesn't mean that nobody is being aggressive. Au contraire, I think they are. But are we living in a different age, a different time? Is it appropriate for George W. Bush to do what he did after 9/11? And I'm just writ large. Is it appropriate for Obama to do what he did post his election? And people can answer that differently. And that's all I was trying to say about
Okay.
that.
Jonathan, do you want to engage?
Really briefly, I mean, Sally and I would agree, I think, that about the general point that folks tend to excuse or ignore the lawlessness of the administrations they like, and you know, there are plenty of examples. We may complain about the Clean Power Plan that's being proposed by the Obama EPA. The Bush EPA engaged in quite a few actions under the Clean Air Act that were profoundly illegal, many number of which got whacked down in the DC circuit. The Bush administration had an appalling record defending air pollution regs in the DC circuit because it was trying to do things that were illegal. I mean, so, and we may like them more as a policy matter, but we should be willing to acknowledge that, and that, for example, while running for president, Romney asserted an authority to implement selectively the Affordable Care Act that rivals what the Obama administration has done. That is to say, Romney said he would, while running, that he was going to selectively grant waivers that the statute doesn't provide for and so on, that look a lot like the sorts of abuses that the current administration has engaged in. So, I mean, I do think that there is a broader trend towards greater assertion of executive authority going back at least, I would say it goes back about 25 years, that has reached a point that is troubling, but it didn't begin with this administration. You know, we can debate about where the tipping point was. Has it been reached just recently? Was it reached in the last administration? But there is a broader trend that should concern us that goes beyond party. Just on the REINS Act, there is no constitutional problem with Congress enacting a revision to the Administrative Procedure Act that imposes requirements on what all agencies must do. If Congress wants that to be only prospective or what we call a super mandate applying to all legislation, Congress has that choice. There's no constitutional problem there. The power to issue regulations is not core executive authority under any Supreme Court precedent, and I think under any fair-minded analysis of Article 2. Morrison versus Olson in some of those cases deal with things that are core executive authority, the power to enforce, not the power to issue quasi-legislative rules of general application that have binding force, the violation of which is treated as a violation of law. And there's a long line of cases about that, and that authority only exists where Congress has given it, and Congress can take it back. And so if Congress wants to say with regulation, like it has done with base closings, like it does with trade promotion authority, like it's done in other instances, we want entities that we've created to have the power to recommend something to us that we will commit to look at on an up or down vote without amendment under expedited procedure, again, as Congress has done many times before, in many other contexts, there's no bicameralism and presentment problem because the change to the law only occurs if both houses of Congress pass the measure in question and the president signs it. And that is why after INSS versus Chadha, people like Larry Tribe and Stephen Breyer said, hey, when faced with a formalist opinion striking down the unicameral legislative veto, the response is a formalist response. Figure out a way to observe the specific formalist rules that the Constitution provides, and that requires saying to, say, the EPA, you get to do little things. If you want to do something big, you have to propose it effectively to us, and we will treat it like a legislative proposal. And to say that's unconstitutional is essentially to say that once Congress has delegated legislative authority, it can't take it back. And that can't be so.
Pass another piece of legislation that does take it back. But
Well, REINS Act does.
This is
I mean, that's
a debate
what the REINS Act does take it back. And I think and I don't see any, just like Congress can amend the APA, and when Congress enacted the APA, it applied to all pre-existing regulatory statutes. When it amends it, it is always applied to whatever regulatory statutes were on the books. Congress can amend it in this more aggressive way and have it apply to all rulemaking processes that are on the books. If it were intruding on enforcement authority, I would agree there might be questions, there might be Heckler versus Cheney type questions, there might be Morrison versus Olson type questions, but rulemaking doesn't present those sorts of questions because it's not core executive authority, and there's no extant decision of the Supreme Court that suggests otherwise.
Well, the two professors have engaged in this debate in the New York University Journal of Legislation and Public Policy, and I hope they will continue it. Let me,
Not here.
but let me now recognize questioners. Although I get to ask two-part questions, you do not. I'm the moderator. Please state your name, your affiliation, and a succinct single question with a single-part question.
Okay. All right.
Andrew.
Hi. Okay. So Andrew Kloster, I'm with the Heritage Foundation. I really, liked Adam's sort of framework. I also commend folks to Susan Dudley's working paper on talking about the kind of different, types of legislation that are out there to deal with the problem. And we've got, amend the APA, amend the Substantive Act, procedure, et cetera. But something that's not talked about, and I'm one of those small minds that likes to discuss people, is personnel policy. And I think one of the major problems here are civil service laws. You can't really fire some of these career staff that have allowed this sort of mission creep over time. So I may be laughed out of town. I'm happy to be laughed out of town. But allowing some of these folks to be more easily fired, this is not, strictly speaking, nowadays thought of as a separation of powers issue, but I think it is, and it's kind of internal to the executive branch, but I think it would have immense, all of a sudden things would be politically accountable, and Chevron would make more sense, et cetera.
Question mark.
Question.
Panel.
Yeah, what do you think? And
Well,
support or oppose?
You had me at, I really liked Adam's framework. But I'll offer an illustration of your point. There's a new book out by a woman named Margot Oge. She used to run, I think, the EPA's air shop. And if I remember correctly, there's an anecdote in her book where the EPA, when they lost Mass v. EPA, the EPA staff literally broke open champagne to celebrate their agency having just lost the case. I think there's something to be said for your point.
What about just applying more rigorously the professional responsibility rules to agency attorneys? So, for example, if they leak internal document that is disclosing privileged information in violation of attorney-client privilege, if they do something that can be shown to undermine the zealous representation of their client, they can be sanctioned. I mean, or is that just too crazy?
I would just add for the audience, I think Charles Murray's book discusses the personnel issue, and he'd have maybe less frustrations with the administrative state if Mr. Kloster's question came to be. Ray, who are you?
Sure. Ray Lajeunesse, National Right to Work Legal Defense Foundation. Congress clearly has the power through the Riders to Appropriations to tell an agency not to implement a rule. But some agencies make regulation through case decision-making. I'm thinking particularly of the NLRB. And the current NLRB has adopted a practice of signaling its intent to overrule years of prior precedents decades actually, through granting review in cases involving those precedents and asking for amicus briefs as to whether it should overrule the rule. Can Congress also, through a rider, tell the agency not to decide that case, not to spend any money deciding that case? And obviously they have to spend money to decide the case.
I think that'd be tough. I mean, when you have a adjudication, you have problems. I mean, it may make more sense for Congress to clarify the nature of NLRB's authority to use adjudication to create rules. I mean, that's a longstanding practice, going back decades. But
Well, let me ask this,
Rider trying to tell
rephrase
an
the
agency
question
how
a
to
little
decide.
bit. If not legislating on appropriation bills is a internal congressional rule that they can violate whenever they feel like it, couldn't they just make the substantive ruling they want NLRB to do in an appropriation bill that the president has to sign? And you could do it in whatever substantive way you're doing so that you're not interfering with NLRB's authority to adjudicate open questions, but you just change the law in an appropriation bill.
There are legal questions as
Sure,
to
go
whether it extends beyond that fiscal year. In other words, if the appropriations rider on an appropriations bill normally covers the expenses and expenditures for that year, can you make it permanent? And presidents of both parties have begged the Congress for clean approps bills.
I don't think you could do it as a substantive. You'd have to say something like the NLRB cannot expend any money to enforce the following rule or to investigate companies for violating X.
Let me
X being-
rephrase. Yeah, no, they don't do it through appropriation language at all. They just put it in, and they just say this law is hereby changed. This authority is hereby repealed, whatever. And they just stick it in an appropriation bill that the president signs.
I think there are legislative rules that make that not kosher.
Oh, I know it's not kosher. Okay.
It's not kosher, but it has been done. President Bush responded to that with signing statements saying he simply would not follow that, and so instruct his appointees that that was not the law because it was inappropriate. And you have other presidents who decide that they will veto even an omnibus appropriations bill and shut down the government. Can you remember that?
Michael?
No, President Bush did not in a signing statement say that he was not going to follow a law because it was part of an appropriations bill because it violated or may have violated a House or Senate rule. He did obviously use his signing authorities for other purposes, but I mean you could do this in either way. You could do it as a funding restriction or as a piece of legislation within an appropriations bill. It is done frequently in both ways. In the funding restriction, you could do it in a way where it's not explicitly deciding an adjudicative matter, but as you said, Jonathan, it would be, you cannot enforce, or no funds shall be spent to enforce this policy.
Okay. Next question. Hopefully we can get two quick ones, but I'm supposed to end close to on time.
Well, I was typing myself notes, so it would be very quick at this point. I'm Mike Doherty. I just want to ask you briefly about this concept of persecution through process, which stops all these issues from bubbling up to get to your attention to know there's a problem to fix. So you don't know, Congress doesn't know, and the administrative state assumes silence means everything's great, when silence means either everyone's dead or they're terrified. So I'm the CEO of LabMD, who's been fighting the Federal Trade Commission in 3 very brief instances. Within the FTC, we now have a whistleblower who's been given criminal immunity from the Justice Department that testifies that they were given flawed evidence, and they probably knew it, but they didn't check. Then you have the 11th Circuit that wants to put their hands around the FTC's throat, but the Supreme Court won't let them yet. So they yell at them twice, but rule they can't get to them yet. And then you have an oversight committee hearing that ISA put a report on where we have forensic evidence brought in, so it's not he said, she said by the whistleblower, but Jay Rockefeller and Elijah Cummings won't look at it because when you won't look, you don't find. So with this type of below-the-scenes protection going on in this city about the administrative state's bad stories, how do you learn that there's something to fix? Because it's pretty bad right now, but I don't think it's really bubbling to the top.
There is a broader problem of government officials being generally immune for engaging in misbehavior. Whether we're talking about criminal prosecutors or we're talking about agency officials, it's an endemic problem. We allow government attorneys to engage on a regular basis, to engage in conduct that were they doing the same thing as private attorneys, they would be disbarred. And I'm not sure if there's a quick and easy solution to it, but that's a huge problem.
Oh, there's not. Thank goodness for hamburger.
Last question.
This will be quick.
Jean, is that okay?
This is a question from Michael Bopp. Why isn't the Congress using the inherent contempt power?
Because there's no political will to use it. I mean, you literally have to have the House and the Senate, Congress use its own authorities to incarcerate somebody. And theoretically, it could be done. I mean, you could essentially put somebody under house arrest. You could have the Capitol Police arrest somebody, detain somebody. It's just
Like the Lois Lerner example, for example.
Well, no, absolutely, and that it was theorized with respect to Lois Lerner. But the problem is the spectacle of it creates, I think, an unfairness problem or an unfairness perception that Congress just doesn't want to deal with. And I understand that, but you could conceivably do it in a way where you don't actually incarcerate the person, but you put them under house arrest. You potentially have penalties if they don't follow the house arrest.
Well, I'm thinking, in the regulatory arena, you create a lot of rules and regulations just by your enforcement practices. I think if Congress actually did it, it might have a chilling effect on administration officials.
I think we'll have to call it at that, but please join me in thanking our panel.
Thank you, and thank you, Todd, for moderating. It's always tough to sum up a day's events, but since Adam White threw out some literary references, I will invoke E.E. Cummings and say today we've tried to get to the root of the root, the bud of these problems. There are some complicated issues here. We will revisit them in our 4th annual conference, but in the meantime, we'll be doing a lot more work in between. So thank you all for coming. Thank you for watching at home.